Hi, I'm Kelsey Vanderbilt, Associate Counsel at Texas Realtors. Joining me today are Robin Harris, Senior Associate Counsel, and David Jones, Deputy General Counsel. We're going to walk through the form changes the Texas Real Estate Commission adopted on November 4th. The redline versions of those forms are currently available on our website. On December 16th, Texas Realtors will be switching to the new forms on our website and through our form vendors. The previous versions of those forms will no longer be available for use through Texas Realtors Forms Library. This is well ahead of the TREC mandatory effective date of January 3rd. Let's start with the changes to the sales contracts. The following changes apply to the 1 to 4 family residential contract, the new home contract, both incomplete and completed construction, the residential condominium contract, and the farm and ranch contract, unless otherwise specified. Let's start with paragraph 4. Here, paragraph 4 is amended to add the term geothermal to the definition of natural resources leases because of a 2023 law change that stipulates property owners own the geothermal energy below the surface of their land and can drill or produce that energy and associated resources. Next is paragraph 6. In paragraph 6C1, to be consistent with the recently updated Texas Department of Insurance procedural rule, the paragraph is amended to include the option of providing the T47.1 declaration, which does not need to be notarized, and that's in lieu of the T47 affidavit when the seller furnishes the buyer an existing survey. While the T47.1 is available for use now through TDI's website, the current 1 to 4 family residential contract does not allow for the use of the T47.1. With the changes to the 1 to 4 contract, we will make the new T47.1 declaration available on the Texas Realtors website and through forms vendors on the same day as the other forms updates. Additionally, in lieu of providing a no survey required option, paragraph 6C2 is amended to read buyer may obtain a new survey instead of buyer shall obtain a new survey, and adds that if the buyer ultimately fails to obtain the survey, the buyer does not have the right to terminate the contract under paragraph 2B of the third-party financing addendum because the survey was not obtained. Moving on to paragraph 6E11. Because Texas law requires a seller to provide a buyer a copy of any mold remediation certificate issued during the 5 years preceding the sale of the new property, paragraph 6E11 is added to provide information regarding this requirement. The unimproved property contract does not have this additional paragraph. Next is paragraph 6E12. Scrolling down to that. So paragraph 6E12 is modified to add specific examples of the types of notices that should be listed in the paragraph and to add a caution that seller's failure to provide required notices may provide buyer with certain remedies like the ability to terminate the contract. Next, we will move on to paragraph 12 with our settlement and other expenses. In light of new practice changes were made to paragraph 12 to allow for the seller to agree to pay buyer broker compensation within the contract. Paragraph 12A1A and 12A2 were amended to add that each party pays the brokerage fees that they have each agreed to pay. And in paragraph 12A1B, it was amended to allow for a specific seller contribution to buyer's brokerage fees. This paragraph creates an obligation for the seller to pay the buyer broker. Members should use this paragraph in the 1 to 4 family residential contract if the seller wants to pay the buyer broker directly. Using the compensation agreement between broker and owner, TXR 2401, and completing 12A1B could create a duplicate obligation. Paragraph 12A1C, that has been added to separately address other seller contributions. This was previously in paragraph 12A1B. The prior language that specified the order in which any contribution was to be paid, as well as the limitation on the type of fee that could be paid, is removed. And conforming changes were also made in the amendment to contract. Additionally, the compensation disclosure in the broker information section of the contracts, down here, find it right here. This was modified to remove the parenthetical referencing the MLS and to add check boxes to allow for the fee to be reflected either as a percentage or as a dollar amount. Those changes were made in all of the contracts except for the farm and ranch contract. So now I'll pass it to Robin, who will cover changes specific to the farm and ranch contract and the unimproved property contract.
Yeah, thanks, Kelsey. Hey everyone, so the next few changes we're going to talk about originally came directly from a farm and ranch task force that we had 2 years ago and forwarded to the broker lawyer committee for consideration. The recommendations were incorporated with this more recent round of updates. So first, let's look at the farm and ranch contract. That's TXR 1701. In addition to those changes that Kelsey detailed, the title of paragraph 20 is changed to federal requirements, and there's a new paragraph 20B, which provides information on the obligations related to the Federal Agriculture Foreign Investment Disclosure Act of 1978, which, among other things, requires foreign investors to report their involvement in U.S. agricultural land, whether that's a purchase or some kind of ownership interest. Failure to do so has significant penalties attached to it. So the committee wanted to make sure, and the commission to make sure that purchasers of these large tracts of lands are aware of the requirement and in compliance. Now, it's important to note that this notice language was not added to the unimproved property contract, but the same reporting requirements would apply if it was a large tract of unimproved agricultural land. Next, unimproved property contract, that's TXR 1607. In addition to those changes made to the sales contracts that Kelsey previously mentioned, the unimproved property contract adds paragraph 3D to include the same sales price adjustment language that's currently found in the farm and ranch contract. These adjustments would be used on large tracts of land that have an acreage variance after the survey is completed so that that price would be adjusted. Next is a new form. It's addendum for section 1031 exchange. It's going to be TXR 1956. The broker lawyer committee drafted this addendum that allows the seller or buyer to disclose an intent to use the subject property as a 1031 exchange, and includes a statement that the parties will reasonably cooperate with one another. The language is similar to what Texas Realtors has in our commercial contract, where 1031s are common, but the committee saw the rise in the financing option as in residential transactions and thought that a form would be appropriate. Providing this as an addendum rather than in the text of the contract allows the parties to use it when it's applicable without causing any unnecessary confusion. A reference to the new addendum for 1031 exchanges was also added to paragraph 22 of the contract. Next is the condominium resale certificate. That's TXR 1921. This is amended so that the language in paragraphs K and L match Texas Property Code section 82.157. The broker lawyer committee policy for contracts and forms that they develop is that if the statute has language in it, then they're going to take that language and mirror it. For example, in the TREC version of the seller's disclosure, they only have what's in the statute. That's exactly what this change is, only mirroring that language in the statute so that it matches. Now, David will discuss the remaining changes that we have coming your way. David?
Thank you, Robin. So first, I will discuss the third-party financing addendum. There were several important revisions made to the third-party financing addendum. That's Form TXR 19 01 in the Texas Realtors Library of Forms. The first change deals with how a buyer terminates under paragraph 2A when the buyer does not obtain buyer approval from the lender. And just as a reminder, buyer approval deals with a loan being approved or denied based on an issue with the buyer, such as the buyer's assets or income and their credit history. That's as opposed to a loan being denied because of an issue with the property, which is covered in paragraph 2B. So under the new language, for a buyer to terminate under paragraph 2A, buyer approval, the buyer must send a notice of termination, which is not new, and a buyer has to send a copy of a written statement from the lender setting forth the reason for the lender's determination. That's new, but this should sound familiar since this is the same requirement under paragraph 2B, property approval. So now you have paragraph 2A and 2B are consistent in that they both require, one, a notice of termination, and two, a written statement from the lender for the buyer to be able to terminate. The second change deals with paragraph 2B, property approval. The new language clarifies the deadline for a buyer to terminate if the lender denies the loan based on an issue with the property. Buyer must give the seller the notice of termination and the written statement from the lender on or before the third day before the closing date. Now, this deadline hasn't changed, okay? It's just that the previous way it was written was causing some confusions, okay? So this change is really just about clarity. So if you have a closing date, let's say is on a Friday, Thursday is 1 day before, Wednesday is 2 days before, and Tuesday is the third day before closing. So the buyer must terminate on or before Tuesday with a Friday closing, and that means sending in the notice of termination and the written statement from the lender. Now, the next contract I will discuss is the addendum for backup contract. Okay, and this is the final form that we'll be discussing today. That is TXR 1909. So in the TREC, farm and ranch and residential sales contracts, so the 1 to 4 family, new home, condo, and unimproved properties, you have paragraph 5, where the buyer and seller agree to the amounts for earnest money and option fee. The changes to the backup addendum now allow the buyer and seller to agree to additional earnest money and option fee that will be delivered only when the backup contract becomes the primary contract. So now you can have one set of numbers to enter the contract originally, then additional money only if the backup contract becomes primary. The provisions regarding issues such as timing of when to pay earnest money and option fee and the consequences for not paying the additional earnest money and option fee, that language mirrors what's already in paragraph 5 in the initial contract. Okay, so you have that automatic extension if the last day to deliver the earnest money option fee falls on a Saturday, Sunday, or legal holiday. The deadline is automatically extended to the next day that's not Saturday, Sunday, or legal holiday. Any amount received by the escrow agent gets applied first to the additional option fee, then to the additional earnest money. The escrow agent is authorized to release the additional option fee to the seller at any time without further notice or consent. If the buyer fails to timely deliver the additional earnest money, the seller may terminate the contract or use their remedies under paragraph 15. And if the buyer fails to timely deliver the additional option fee, the buyer doesn't have the option to terminate. One question that comes up with this change is, well, can you put 0 as the initial earnest money and option fee in paragraph 5 of the sales contract and only put money for additional earnest money and option fee in the backup contract when it becomes the primary contract? Well, it's not recommended to have 0 as either the initial earnest money or the option fee. For the initial earnest money, you don't have to have earnest money for an effective contract, right? The earnest money is not the consideration. But I would imagine that a seller would probably want the buyer to have some skin in the game to sign the initial contract. And for the option fee, well, paragraph 5D of the sales contract specifically says, if no dollar amount is stated as the option fee, the buyer shall not have the unrestricted right to terminate the contract. So probably not a good idea to have $0 amount for the initial earnest money and option fee, trying to save everything just for the additional earnest money in the backup contract. And with that, I will turn things over back to Kelsey.
All right, thank you, Robin and David. To recap, the red line versions of these forms are currently available on our website. The updated forms will be available on the Texas Realtors website and through our forms vendors on December 16th. And additionally, the addendum regarding brokers' fees, TXR 2406, and the amendment to representation agreement, TXR 2701, will no longer be available starting December 16th. If you have any questions about these forms changes, please contact the Texas Realtors Legal Hotline at 512-480-8200. Thanks for listening.